Welcome. I'm glad that it's a packed house today. We're here at the Leatherneck Club in Las Vegas, Nevada, a place that has defended our rights on multiple occasions. It's a Marine Corps facility, and I'm a son of a retired Marine, and so I'm proud to have this Know Your Rights seminar, police encounters, here at the Marine Corps League and the Leatherneck Club. So thank you, and thank you all for coming. We are Facebook Living this, as well as recording it. We'll post it on YouTube later. There's been some things going on that I'm not too happy about. Since the year 2010, I've been dealing with police and internal affairs about what police are allowed to do and aren't allowed to do. And about 3 years ago, I thought we kind of had things settled, and things did settle down. But this last weekend, some things happened here in Las Vegas that are very concerning. So today, I'm going to go over the laws. I'm going to talk Supreme Court cases. I'm going to talk United States Supreme Court cases and Nevada Supreme Court cases. I'm going to talk statutes. This will be chapter and verse. And I hope that police officers watch this because they took an oath to support and defend our Constitution. And unfortunately, there's some police officers that want to get away with whatever they can. And so they have that attitude instead of the attitude that, hey, we have a Constitution, we're Americans, and that Constitution should protect us. So today we are going to talk about those rights. A couple housekeeping matters. Please turn off your cell phones. Also, this presentation is Nevada law. I am a Nevada attorney. I am not licensed anywhere else. There are parts of this that are federal that would go to other states. However, Nevada also has some special protections because states are allowed to give more protections than the Constitution. However, they're not allowed to give less protections. Nevada is one of those states that has given some more protections. It's a beautiful thing when our Nevada Constitution and our statutes protect us more against our government instead of less. So please, if you're in another state, watch this, ask a local attorney. Look at things in your state, because if you're in Nevada, even if you're visiting Nevada, this is the law. If you are on probation, or a parolee, don't use any of this stuff. You are on a contract with the state to where you are not in prison. In exchange for you not being in prison, you waive all kinds of rights. So please, yes, sir, is all you need to say, because you do not have constitutional rights because you waive them so that you're not in prison. That's the way it works. This is important. It's a big warning I'm putting at the beginning. There's a price to pay when you stand up for your constitutional right. There is a serious price to pay. If you do not know, and if you are not correct, if you do not know the law and you refuse a lawful order, you are guilty of obstruction and you can go to jail in Nevada for up to 6 months. Okay. You must know your rights before you exercise them. It's very, very serious, okay? Don't pretend to know them. Don't think you know them. Do whatever the officer says unless you know otherwise, because it's very, very, very serious. Now, you could even be right, and the officer could be wrong, and you could still get arrested for obstruction, and you could still go to court over it. You'll have to fight, okay? Even if you're right and even if they're wrong. That's just a reality of life. And it happens. It's happened to me. It's happened to a number of my friends. And we fight and we take care of things. But you've got to know that there is a price to pay for exercising your rights. If you're not willing to pay it, then waive them. All right? That price to pay is knowledge. You have to know them, and you've got to be willing to stand up. And you have to be right. And I'm so sad for people who, in good faith, try to do things and they're wrong. So sad for them, but that's the law, and there's no good faith exception to that. So that's just the way it is. By the way, if police officers make a mistake, they still go home to their families. Nothing really happens. They might go to internal affairs and have to get new training, but on the other end, it's not exactly the same thing. But warning, you have to know your rights. You have to know the law. And if you don't, I wouldn't play this game. I just wouldn't, okay? Know what you're going to do, okay? Police can lie to you. Guess who said that? The United States Supreme Court. In Fraser v. Cupp, police are allowed to lie to you. They are allowed to tell you false things. They are allowed to tell you false things about the law. They're allowed to make up laws that don't exist. They're allowed to do all these conniving things if they wish to try to get you to do what they want you to do. It is 100% constitutional. I don't particularly agree with this, but that's the law. And we have to deal with the law, and we have to deal with what the United States Supreme Court has said since 1969. So just know that. The police can lie to you. However, you can never lie to the police, not even once. That is a crime punishable in the state of Nevada up to 6 months in jail. So police can lie to you all they want, which is why you need to know the law, because they can very forcefully tell you things that aren't true. Can lie to you. You cannot lie to police. Don't do it. It's against the law. Today's agenda, we're going to go over filming police, constitutional police encounters, what they are allowed to do under the Constitution, illegal seizures under the Fourth Amendment, Nevada's 60-minute rule, Nevada's duty to identify statute, police illegally threatening businesses, that's happening, and then also how to properly handle a general police encounter and also a traffic stop. That's today's agenda. Again, we are going to be talking laws. We're going to be talking Supreme Court cases, both Nevada and United States Supreme Court cases, and we are also going to be talking about the statutes. This is something you can take to the bank, you can look up, you can watch this later. I'm giving you citations. Filming police. In the state of Nevada, you have a First Amendment freedom of press right to film police. Freedom of press right. Now, that started in 1995 in the Ninth Circuit. They made a very general ruling, but that's the way it was. Then in some other circuits, they made some rulings finally in 2012. ACLU of Illinois, they won a case that even went up to the United States Supreme Court, and they denied cert. Okay, what does that mean? That means the Supreme Court looked at the result of the case and said, do you know what? We're going to let that one stand. That's great news. However, it's not binding on the other states. So there is clear law established in the First Circuit, the Seventh Circuit, the Ninth Circuit, and the 11th Circuit. 19 total states. I'm going to read these off. Nevada, Montana, Idaho, Oregon, California, Alaska, Hawaii, Arizona, Alabama, Georgia, Florida, Illinois, Indiana, Wisconsin, Maine, New Hampshire, Massachusetts, and Rhode Island. There is clear law established, binding authority in all of those states through the circuits, that you have a First Amendment constitutional freedom of press right to film police if they are in public performing their official duties. That is the law. That's the way it is. There is one judge at the lowest federal courts in Pennsylvania that decided to say you don't have that right. That's been appealed by the ACLU. We'll see what happens there. The other jurisdictions generally accept what's going on. This is generally accepted, and so you should be safe in the others. However, it's not binding authority. But you can film police, two things, in public, performing their official duties. That is your right, okay? In every police encounter, the first thing you should do is you should start filming. This is very dear to me because I was representing a client once, right actually here in front of the Leatherneck. I was representing a client questioned by police, and gang task force showed up. Sergeant Utomi showed up, and she ordered me to leave so that she could question my client without me there. I refused. She arrested me. And I thought, you know what? The truth will come out. Everything will be great. My stomach dropped when I read the police report that was submitted to the district attorney because it was all fiction. It was fiction. And if it were true, I would be guilty, and I would likely lose my law license. I cannot explain what that feels like when a police officer lies in an official report and it's against you. And actually, she actually wrote two reports. We found out later she wrote a more truthful report, and then the report she submitted to the DA, even though the DA asked for all reports, she pocketed the other one that was truth of what happened. She pocketed it, and she let the trial go on. Luckily, a friend of mine pulled out his cell phone and he videotaped. And he caught it. You can watch it if you want. Go to YouTube and search Stephen Stubbs arrested. And you'll see it, and it's there. I am so grateful to him, and I will always be grateful to him, simply because he pulled out a cell phone and he videotaped it. Because that videotape was shown in court during the prosecution's case, and Judge Eric Goodman, right after the prosecution closed their case, said, this is ridiculous. You're not guilty, Mr. Stubbs. You don't even have to put on a defense. And I am so grateful that it was videotaped. Videotape is something to where it can't lie. It's a perspective, right? It's not always all, right? But you know it's not lying to you, right? Video is so important anytime that you have any kind of case against the police. So please, the very first thing you should do whenever you encounter the police is to start filming. Film your buddies. If your buddy is talking to police, film them. And film the person that's filming. We recently had a case where someone was filming and the police came up to them and the police arrested them and the police said some things and we didn't have anybody filming them. So we didn't have any evidence, some hard evidence that said he was not doing. There were lots of people around, and so if you see someone filming and you know they got that shot, film them. Step back. You can film the police and film them at the same time. That's a way to protect yourself, and it is 100% protected under the First Amendment freedom of press right in the state of Nevada and also in those circuits, and most of the United States will support that. Constitutional police encounters. What are police allowed to do? There's a couple standards, and depending on the standard, they can do different things. There's reasonable suspicion, and there's probable cause. They have different encounters. What are police allowed to do? There's a couple standards, and depending on the standard, they can do different things. There's reasonable suspicion, and there's probable cause. They have different powers depending on what standard they have. So we're going to talk about those standards. Okay? Reasonable suspicion. This is the standard to detain. If a police officer has reasonable suspicion that you have committed a crime, are now committing a crime, or are about to commit a crime, they can detain you to figure some stuff out. 100% constitutional. That's the way it's supposed to be. It has to be more than a hunch. They have to be able to give specific and articulable facts. That's what the case law says, which means they have to be able to say, do you know what? I saw this, I saw that. And they have to be able to articulate those facts. Okay? If they have that, they are allowed to detain you. And in the state of Nevada, where we have extra protection under NRS 171123, they are only allowed to detain you for a reasonable amount of time to effectuate the purpose of the stop, not to exceed 60 minutes. But only a reasonable amount of time is what you have in Nevada. Not all states have that. Nevada is special, and I'm grateful for it. But they can detain you for a reasonable amount of time to figure some stuff out. Probable cause is a higher standard. That's a reasonable belief standard, right? Most people say, you probably did it. The Supreme Court said that there has to be slight or marginal evidence in the state of Nevada. But if they have probable cause, that is the standard for both a search warrant and an arrest. It's stronger than reasonable suspicion. It's not as strong as beyond a reasonable doubt. And again, law enforcement needs to be able to articulate specific facts of what's going on in order to have that standard. They need to put it in an affidavit for a search warrant and also an affidavit if they arrest you. They need to be able to articulate those facts. So those are the two standards. Now, what can they legally do in a traffic stop? Okay? Because traffic stops, they're their own little thing. Okay? Number one, they get to demand your license, registration, and insurance. If you do not provide that for them, you are committing a crime and you can be arrested and you can go to jail for up to 6 months. Even if your stuff is good, if you don't have it on you, that is a crime. And you can fight it later and you can get it dismissed. I do that all the time. However, have all your stuff and have it ready, because they are allowed to demand your license, registration, and insurance, and you must give it to them, okay? They're allowed to ask questions. However, you don't have to answer. That's also 100% constitutional. If they are afraid of you, they are also allowed to have you and everybody in the car get out of the vehicle, and then they can search both you, they can pat you down for weapons, and they can search, they call it your wingspan. It's the entire inside of the car, but not the trunk. And it's for their safety, and the Supreme Court has carved out that exception for officer safety. So if they are afraid of anyone in your car, they are allowed to do that. They can tell you to get off your bike. They can do that. They can even make you sit down on the sidewalk. That is 100% legal and 100% constitutional. And at a traffic stop, they are allowed to detain you for a reasonable amount of time to effectuate the purpose of the stop. That is a traffic stop, right? Reasonable amount of time. Different courts have thrown out some numbers. The Second Circuit says it's 9 minutes. Another circuit said it's 20 minutes. It just has to be reasonable, okay? If they try to extend that, then it's not really reasonable, right? If they're asking you other questions. But as long as the officer is just pulling you over and is just doing a regular, ordinary traffic stop, that is 100% constitutional. Please don't tell people that it is unconstitutional for traffic stops, because that is just not true. Okay. If you choose to talk to them, if you choose to answer their questions, you are voluntarily extending that time. That you can do that. You're consenting. That is also constitutional, and you can't come back later and say, oh, this lasted 27 minutes, oh, they violated my rights. No. If you want it to be as short as possible, you just politely don't answer their questions. Because if you begin and you start answering their questions and you want to have a conversation that is consensual, even if you don't want to be there, it's consensual and you're extending the time. Now, illegal seizures under the Fourth Amendment. There's a very, very important 2005 case, Torres v. State of Nevada. It's an Elko case. And there was a guy who looked pretty young. And he had an alcoholic beverage in his hand, and he was walking down the street, and a police officer saw him, saw he looked young. Did he have reasonable suspicion? Yes. He can specifically articulate, you look young, you got alcohol in your hand. So he detained him and said, you look young, you have alcohol in your hand. The gentleman produced an ID that proved that he was at least 21. Now, that officer then said, thank you, just a second, and he did a warrants check. After the reasonable suspicion was already gone. And the Nevada Supreme Court case said very clearly, no. You cannot do that. You can't hold on to someone's ID that long. You can't detain